Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam podcast from the American Bar Association's section of Antitrust Law. My name is John Roberti, and today's program is this a tragedy of the commons? Antitrust law and open source licensing. Open source licensing has become an increasingly important way for companies to bring products to market, for technology to develop. And by nature, it is open source, so there is open access. But there's also the potential for abuse. And today we're going to talk to an expert who's going to talk a little bit about the role of antitrust law and other processes to make sure that open source coding continues in a way that will be productive. My co-host today is Tammy Sue. Hi, Tammy.
Hey, John.
Tammy, what are we doing today?
Today, we're going to be talking about open source licensing and the role of antitrust laws in some recent dilemmas that we've seen. In the past few years, the open source community has seen a trend in which cloud providers have been taking numerous open source projects that they didn't create and then monetizing these projects as hosted services. The act of hosting an open source project isn't itself illegal because these projects were open sourced. However, the problem is that very quickly and without doing most of the legwork, these cloud providers are successfully taking revenue away from and out-competing the creators of these open source projects, who are the people who did most of the work.
All right, so who's our guest today?
Our guest today is one of the nation's leading open source lawyers. She's written and presented a lot of materials on open source software. She advises many of the open source companies who have faced these competition challenges from cloud providers. And she's actually drafted many of the alternative licenses adopted by these open source companies in response to the cloud provider threat. She used to chair the ABA's committee on open source. She also used to work as a software engineer. We are speaking with Heather Meeker today.
Heather, welcome to the program.
Hi, Tammy. Thank you very much. It's a pleasure to be here.
So, Heather, why don't we start with some background? What's so special about open source software? How do open source licenses fit into the world of software licenses as we know it?
Well, there are two things to understand about open source software licenses that bear on this issue, ultimately. I think when you say, I'm going to start again because there's some noise. When you ask most people what is open source, they have a general sense that it's free of charge and that the source code is available. And of course, those are two characteristics of open source software. But there are also some other important characteristics. First, open source software licenses are unrestricted licenses. What that means is that the licensor who makes the source code available allows anybody to do anything they want with the software. It is unrestricted. Now, there can be conditions applied to that, like source code sharing or putting license notices or attributions on certain uses. But it's important to understand that the license is unrestricted. That is a feature of open source licenses. In something called the free software definition, that is known as freedom zero. And by the way, it starts at zero because in computer programming, you start counting at zero. And it's the most important freedom, which is basically the freedom to use the software for any purpose. That's one characteristic that's important. Another characteristic is that open source licenses are conditional licenses and not contracts. And so what that means is that the license imposes whatever conditions it imposes as a quid pro quo for exercising the copyright rights in the software. And a corollary of that is that the licenses can't control anything that is not controlled by copyright law. And we'll probably end up talking more about that in a bit. But the point is that if I make some software available and you have certain rights to do things to it without a copyright license, then the open source license can't control that. And by the way, the copyright law says that if you legitimately have a copy of software, one of the things you have the right to do is run it. Actually says that in the statute. And so merely running software is not something that's generally controlled by open source licenses.
Heather, that's really helpful. Thank you. So how do these features of open source licensing, open source software get these companies who build and provide open source software into competitive issues with cloud providers?
So those characteristics of the licenses mean that for every open source license there is, a cloud provider can freely use the software all they want. And by the way, they can modify it too. And open source licenses grant rights to distribute. But when you're providing cloud services, you're not distributing software. So you're as a cloud provider, what you're doing arguably doesn't even require a copyright license. And certainly none of the licenses seek to restrict people from using software in order to provide cloud services. The furthest they go, and when I say they here, I'm talking about sort of the most common and approved open source licenses. The furthest they go is to say that if you use a software to provide a cloud service and you change it, you have to share your source code changes. But there's really more or less only one license that says that. It's called a Faro GPL. And even a Faro GPL allows people to use the software without modifying it, without restriction. So what that means for these smaller developers is that if they release their software under an open source license, any cloud provider can use the software all they want to provide cloud services, subject to some probably very limited conditions. That way, what that means is that the developers can kind of become the unpaid development shop of some very large companies. And those large companies have a lot of customers who are interested in using some of this software. So it means that the cloud providers can leverage what another company did to make a lot of money without ever giving anything back to the developer. Now, I'll say one more thing, and that is that some of the cloud providers, notwithstanding that they don't have the obligation to help the developer, actually do help the developers because they want the software to be great software and they don't want to develop it on their own. But there's no actual legal obligation for the cloud providers to share anything.
I see. So can you go into more details on what we're seeing these cloud providers doing? Like, is it, my take is that they're taking the open source projects and sometimes they're forking these projects and then they're hosting them. Can you go into more details about what you're seeing?
Yeah, so starting in about 2018, we saw some of the more successful private companies that were doing open source start to get very concerned about this issue. By the way, the issue is sometimes referred to as strip mining. I think that's a little incendiary way to talk about it. But they were concerned that they were leaving too much on the table. So as you mentioned in your introduction, the cloud providers, for the most part, had done what they were allowed to do under the licenses, but they weren't playing nicely in the sandbox. They were not contributing back to the developers. So the developers decided, okay, if that's the way you're going to be about it, then we're going to either move to things that aren't open source licenses and say that you can't stand up a competing SaaS product using our software. Or another thing they do is they start bifurcating licenses. And actually, most of the companies that are in the news about doing this do the two-pronged approach. So they have something that's under an open source license, but then they have some other pieces that are under more restrictive licenses. And those other pieces are generally the pieces that are necessary to use the software at scale. So if a cloud provider wanted to run the software at scale, they could only use the basic part, which is under the open source license, and they'd have to buy the rest of it. That other category of licenses that the companies are starting to use is an emerging category. It's sometimes called source available because the source code is available and the licenses usually grant people the rights to modify the software, distribute it, and so forth. But they say that you can't stand up a competing SaaS service.
So if these companies, if they don't want cloud providers to take their product and provide a competing SaaS solution, then why not just completely take the code off of open source or source available? Why keep it that way?
Well, I think there are two reasons. The most sort of, I guess, easy to understand reason is that because of the enormous growth of open source software in the technology environment, customers are now accustomed to getting source code. So it's become harder and harder to actually sell licenses to software products that are not delivered in source code form. If you go back 15, 20 years, lawyers like me were negotiating software escrows for source code all the time. Today, we hardly do it at all. And the reason for that is that customers now have this expectation of receiving source code. The other reason that companies want to keep at least part of their software as open source is to facilitate adoption. So as a business strategy, it is extremely effective for a company to put something out under an open source license in order to get people to adopt it quickly and get interested in it. The reason for that is that if you use most kinds of open source licenses, engineers at your customers will have the ability to get the software, play with it, see if they like it, give you feedback on it, etc., in open source style. And most companies will not impose any limitations on their ability to do that, particularly if the software is available under something that we call a permissive license, which just basically says, do whatever you want with this, and doesn't have any source code sharing, like modification sharing requirements. So it's a very effective business strategy to say, okay, here's our open core. That's the name that you give to this. And it's under, say, Apache 2 or MIT. Those are both permissive licenses. Everybody use this, have at it, do what you like. It serves as kind of a proxy for an evaluation agreement. You don't have to use evaluation agreements. You don't have to get anybody to sign anything. People start using it. And then if they're interested in the additional features, they come back to negotiate with you. This business model has been extremely successful in recent years. And that's why companies want to keep at least some of their software under open source licenses.
I see. Thanks for that, Heather. I want to take a moment to talk about anti-competitive concerns of these cloud providers' behavior. I know that your focus in the law is open source and licensing, but do you think that the cloud providers here have engaged in anti-competitive or unfair business practices? What arguments have you seen on both sides of this dilemma?
Well, as you say, I'm not an antitrust expert, although it's near and dear to my heart because I once upon a time studied economics. But the thing to me that's most interesting about it is that the cloud providers have, the large ones have this incredible customer base. And so if you're a customer of a cloud provider and you want to add this additional piece of open source software to your cloud platform, it is easier to press a button or check a box and add it to your existing account than it is to go and negotiate with another company that you might not know, and you'll have to sign their terms and so forth and so on. So the cloud providers are in the position to leverage their existing large client base to take business away. So let's say I'm a smaller developer, private company, and I have created a really great database, right? And so somebody is an existing customer of a cloud provider, and they have to make the decision, should I just add this to my cloud account, or should I go negotiate with Heather to provide software as a service from her? I don't know who she is. She's a small company. I don't know if I can trust that she'll be around, and all the usual business concerns that people have dealing with smaller companies. So it's just easier, and it's frictionless for the customers to just add to their existing accounts. So in that respect, the cloud providers are leveraging the size of their business in order to compete with the small companies. And that could be considered an antitrust problem, although I certainly don't have to explain to you that it's more complicated than that.
Very interesting. So just to, in sort of my non-technical, from my non-technical viewpoint, it sounds to me like the developers are creating a product that is designed to be put out there. It improves by being put out there and people working on it, and they get a benefit from doing that. But they've run into maybe what we would call opportunistic behavior by the cloud providers.
Right. I think that's right. That's right. And I'll emphasize again that some of the cloud providers, in any case, will do deals with the developers and support them in various ways. But not all of them, because they're just not legally required to do that. And if I could just take one little detour for a moment, I'd like to make an analogy. This same question was playing out 20 years ago plus with the Linux platform. And for the Linux platform, the license that applied to that, which was a general public license, actually compelled people to share source code if they distributed. Well, 20 years ago, almost all software was on premises. And so if you were using Linux, which was a fantastic product, you had a legal compulsion to share. And so a lot of companies that were very reluctant to share kind of got to the point where they realized they had to share for legal reasons. Today, those assumptions don't hold anymore because all the software is, going to the cloud, and the open source licenses can't control that behavior. So you don't have the legal hammer that you had with Linux. But one thing you do have is that since the whole industry went through this whole thing with learning to share infrastructure because of Linux, now there are a lot of companies who have a different attitude and they're willing to share anyway. It's just that we don't have the legal hammer anymore, except when people move to these alternative licenses.
So in my sophomore poli-sci class, we studied something called the tragedy of the commons. I think people are going to be familiar with it. It was, the idea is in a New England town or someplace, you would have a commons and people would bring their animals to graze on the commons. And if everybody brought their animals to graze on the commons would be destroyed. And that was the kind of the idea. If you have if we have a commonly owned benefit property, something like that, and people take advantage, it could ultimately destroy it. Is that kind of what's going on here?
Yeah, there are a lot of analogies. Open source is often referred to as a commons of intellectual property rights. So when you put the software out there, anybody can use it. And the thing that's different about the real commons and the software commons is that the software can be used costlessly by everyone. So they're not degrading the commons in that sense, but software needs to be maintained, and that takes resources, and it takes capital or contributions or whatever you want to call it. And so when too many people use the software but don't contribute back to maintaining it, yeah, you can have the software degrade. In fact, that is what happened with one of the famous security breaches that happened a number of years ago, it was for a very small open source project that was nevertheless extremely popular called OpenSSL. And there was a security problem. And the reason there was is that this thing was run on a shoestring, maintained by like a few guys. And all the companies that were using it were not really contributing very much to the maintenance of the project. So this has been an issue in open source world for quite some time. How do you maintain the commons when people aren't really obligated to help maintain it? But there is some aspect of maintenance that's important, mainly for security, that applies to software the same way it would apply to a field of grass.
And this is really interesting. One of the things I think some of our listeners are going to grapple with is we as antitrusters get very uncomfortable when potential competitors have to cooperate, collaborate to maintain something. Now, certainly if there's a collaborative joint venture, there's a long history of this. The BMI case talked about the benefit of a joint license. We understand that concept, but it seems to me that there is tension between wanting to compel different people to cooperate or contribute, and at the same time maintain, the aggressive competition. Is that an issue you've run into? How do you think about that as you're licensing?
Well, interestingly, long ago, somebody brought a legal challenge to the general public license based on antitrust grounds, which was summarily thrown out by a district court, and we really never heard much about it again. The fact is that today, for a lot of the big infrastructure projects, they're done through foundations that have memberships from big companies, and they have robust antitrust policies. So the companies have figured that out. But you do need to think about a license like, say, the general public license as very similar to a big patent cross license or something like that. It's generally a pro-competitive vehicle, and the trickiness involved in people collaborating has to do more with their ancillary behavior than the actual license. But companies are very attuned to this, and most big projects that have big members have antitrust policies that say all the things you would expect them to say, like don't talk about restricting output or setting prices or anything like that. But that's an issue that the industry has totally learned to deal with respect to open source at this point.
When you say ancillary behavior, what are you getting at?
Well, you could theoretically have companies who are collaborating, getting together and saying, let's put these features in so we can close these other people out of the market, or something anti-competitive like that. And so a lot of the bigger projects that run through public foundations, they're usually nonprofits. They have some fairly specific guidelines about how people participate. Also, by the way, it helps that for open source development, for the most part, it all takes place completely transparently and in public. So it's hard to make side deals and have secret arrangements when you're, say, developing software on GitHub, which is the main development platform for open source.
So there's a saying that's, if you can't beat them, join them. And we do see some companies that have open source products partner up with cloud providers. Is that have you seen that be an effective strategy to thwarting cloud providers from just kind of monetizing, hosting the open source projects themselves?
Yeah, I think it's very effective. And some of these collaborations are informal and some are formal in the form of contracts. And by the way, they're not always completely visible to the public eye. But if you were a big cloud provider, you might find that it makes a lot of sense to engage the developer to do some development work for you, for instance, so that you're sure that their software plays nicely with all your other software. So there are plenty of reasons to do commercial deals, and people do them, with some frequency. It's just that the open source licenses don't have the legal clout to bring people to the table for that kind of deal.
I know in the summer of 2020, the House of Representatives put out a fairly extensive report, rumored to have been authored, at least in part, by the current chair of the Federal Trade Commission. Were some of the issues that you're talking about today covered in that report? What was the perspective?
Yeah, they were definitely covered by the report. I think the report was a lot broader than just the issues I've discussed, but it was it definitely, I think it spent a page or two talking about this topic and used as some examples some of the clients I've worked with and some of the companies that everybody knows as having addressed these issues.
And where did the report come out? Did in those couple of pages, were they expressing concerns about some of the behavior of the cloud providers?
The way I read it, they were expressing concerns, but more in an open-ended way. I didn't think they came to a conclusion, but I think everybody has understood in the open source and software world for a long time that this is a very live issue for businesses in open source. One thing I'll say about this is that one of the changes that we've seen in the last 10, 20 years is that a lot of the open source software is being developed by private business now. It used to be that it was more squarely in the realm of community and collaboration, nonprofits and so forth. And so in a way, you can't compete with a nonprofit entity, right? But you can compete with private entities, and the juxtaposition of the business interests of the small developers and the big cloud providers is what has made all this come to a head.
So Heather, if I am an open source company, or if I'm a company that has an open source product that can be run on a cloud service, should I be concerned? Or are we seeing certain kinds of open source products be hosted by these cloud providers? What kind of insights can you give us here?
Well, there's plenty of opportunity to put together a business model that will address these issues, but it's not super simple to do. And just to summarize very briefly, first of all, you have to have a very strong branding policy, because the branding doesn't get licensed through the through the open source licenses. It's trademark, it's different. The other thing is that most companies are gravitating towards this open core model, or figuring out some way to add value that the cloud providers can't add. So you have to do some strategizing about that before you can actually create a business model. And that is something that I actually work with a lot of companies on doing.
Where do you see the chips falling here, Heather? If you had to make a prediction, what's a likely middle ground outcome that you think we'll see in the next, 5 to 10 years?
Well, so I think that the open core model is the sector of the future. I mean, I think that lots of companies like developing open source software. They like having their open source core as a way to develop a community around their software. But many of them have decided that going full on open source doesn't create a sustainable business model for them. And so we're seeing more and more companies who are going forward with this model. By the way, I'm also a venture capitalist, and that's what we invest in. We invest in people who are doing open source based businesses, and that model is very popular. I think that's just going to get more and more of the software sector in the next 5 years.
Heather, this is fascinating stuff. Obviously, this is an issue that is not new. As you said, 20 years ago, you were running into similar issues. So let's stay in touch. And I think as things develop, maybe we can have you back and learn more about this. Very, very interesting stuff. But let me shift gears and ask you this question. Do you have any advice for younger lawyers who want to get into, do what you do?
Yeah, I have some advice. It's that, so I took the route of being a specialist. I mean, really a specialist, right? And that's one route to go as a lawyer. To be perfectly honest, I don't think it's the route that makes you the most money, but it is the thing that gets me out of bed every day into my desk. I really love these issues. I love digging into the complexity of it. That's what I like. And you really have to do something that, I hate using the word passion. It's overused. You have to do something that excites you and makes you interested in coming to work every day. If you don't do that, the legal profession is too stressful to bear, right? You have to really love what you're doing. But at a certain point in my career, I decided, okay, what I really want to do is I want to be as good as I can be in this one particular area. And that's one path to go down. It's not the only path to go down, but I made that choice and I'm glad I went down that path because it works for me. There are other paths to go down. People who are generalists, usually work on bigger matters. And if they're successful, they make more money and they have a wider client base. So that's just a different approach to your career. But once you've sort of established yourself as a lawyer, it's good to sit down and think about what you really want out of the career. It's potentially a long and wonderful career. And so, but you need to go for what works for you.
And Heather, when was it that you decided you were going to be a specialist? Was it going to law school? Was it at some point early in your career or mid-career? When was it that you decided you wanted to take that path?
I had been practicing a few years when I first learned about open source licensing. And to some extent, it was dumb luck, right? Because there were these licenses and nobody seemed to understand them. And most importantly, the lawyers at the time didn't seem interested in them because they viewed the licenses as being relating to hobbyist activity, which a lot of it was at that time. But I found them fascinating. They're actually, like, the GPL is a very complex document. You have to understand a lot about copyright law. You have to understand something about software development, which I fortunately did know something about. And so I thought, wow, this is really interesting stuff. So I really should learn about it. And then people started asking me questions about it. I started answering the questions. I started doing more digging in order to answer the questions. I found there was almost nothing written about it. So I started writing stuff about it. And the way that specialties work is that if you like a specialty and you just tell people that that's your specialty, they'll come to you with questions and it will just feed on itself, right? The flip side of that is don't admit you know how to do anything you don't like doing, right? Because then you may end up being the specialist in that too. But so I kind of fell into it. But then again, I found it absolutely fascinating. It combines weird politics, technology, intellectual property law. To me, that's just like the most fun. And so, in everybody's work, they have, you'll come across something and go, I really like that thing. You just got to grab onto that thing. And so I fell into it a little bit by accident. But once I did, I thought, well, this is really what I want to do.
It's interesting to hear you talk about this because so many of us who practice in antitrust or consumer protection, we're viewed just by virtue of being an antitrust lawyer or consumer protection lawyer as being specialists in and of themselves. And actually within the bar, there are people who are sector experts. So you might have somebody who what they're really good at is doing consumer protection work for banks or doing antitrust work for telecom companies. So it's interesting. And I think people at different points in their career, and often by accidents, you might become an antitrust healthcare lawyer because you do a bunch of antitrust healthcare cases and you get good at it.
That's exactly right. And you just have to be attuned to you have to be ready at all times to jump on the thing that interests you. That's the most important thing for junior lawyers to understand.
Exactly right. And at the same time, it's not a commitment. So you could very well have taken this path, been very good at the open source licenses, but maybe do other things as well. I mean, I think there's definitely, my takeaway is taking an opportunity to get some depth in a particular area is never a bad idea, whether you choose to do that most of your time or not. That can be pretty flexible.
Yeah, I mean, that's what's great about the law as a profession is there's so much opportunity to pursue the things that interest you. There's so many different areas and it's so, complicated. By the way, this is my third career and definitely the best. I just want to do a shout out towards how great it is to be a lawyer because a lot of people hear exactly the opposite. And in fact, it's a fascinating and challenging profession. And I love the clients I deal with and so forth. And so that's the great thing about it. It's like there's always some area that's going to interest you.
All right. Well, let's change gears. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, I was at one time a professional musician. And by the way, most people who know me professionally know that. but I guess some of them are a little surprised. For a while, I ran a rehearsal studio and I played music professionally, which usually meant I had another part-time job. I went to a music trade school. It was a 1-year program and got a certificate in percussion. And I'm more proud of that degree than any of the other ones I have because it was harder.
Tell me you were a drummer in a rock band.
Oh, I'm still a drummer in a rock band.
You don't happen to have your kit right there, do you?
No, I have my electronic drums that you can't see them in the background.
And there's no chance you do a solo for us right now.
I don't do solos.
Well, that's a shame. All right, let's go to our final segment that we call The Curious Hat.
And now it's time for The Curious Hat.
Heather, when we're together, we have an actual hat, and in the actual hat there are actual pieces of paper with questions on them, and the guest typically pulls out a piece of paper, and then we read the question and the guest answers. Since we're doing this remotely, I have a list of questions in my hand. I'm going to ask you to choose they're numbered from 1 to 25. I'm going to ask you to choose a number, and I will read you a question that corresponds with that number.
15.
Okay, question number 15. What do you wish you knew when you started your career?
What do I wish that I knew when I started my career? That you can do this career without losing your personality and your whatever makes you special. People, you should always resist any pressure to conform to other people's expectations and just do what you want to do. That's all that's worthwhile in the long run. And anything that I did early on to try to, behave like other people instead of like myself was a waste of time. So that's what I wish I'd known then.
That's great advice. And so, Heather, thank you for being on. Next time you come on, let's make sure you bring your drums. And we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org. Antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.